The Proud Boys trial was closed, and this was a major bummer. Judge Kelly cut off media access to the Proud Boys trial day 55. Here's what Brandy Buckman reported at 6:10 a.m. She says, "Now, I'm hearing that the media room access is being cut off for the rest of the trial. The reason seems to be something to do with the court's own mistake last week about broadcasting a sealed hearing temporarily." And we're saying that's a big problem. We know that there's been a ton of sealed hearings in this case. We know that the media has had concerns about that. They filed and lodged their complaints with the court. Judge Kelly has said, sorry about that. It's sealed and you don't get access to this because this is all national security stuff, or it's protecting sources and methods from the FBI or whatever. And so we were a little bit surprised to hear this. And the reaction in the media was very unhappy. People were upset that this was going on. Kyle Cheney over at Politico dropped a couple of tweets about this. He said, Judge Kelly has blocked the media's real-time access to the Proud Boys trial because of the court staff's own error last week when they streamed a sealed hearing into the press room. We're going to learn more about that hearing in a minute. That will significantly impede coverage of the two defendants who are testifying. Cheney says it's astonishing that in one of the most important trials in America right now, the court is going to significantly curtail access to the trial 4 months into it, punishing the reporters for trying to inform the public about it. Says the backup option, of course, is to go into the trial, into the overflow room, but no devices are permitted there. So live and verbatim coverage of the trial is impossible. And then you risk translating incorrectly and saying something and then somebody takes it and runs with it. So it's not as real time. Kyle says, so coverage will happen, but it's going to be slower. And this comes as we're nearing the end of this thing. Zachary Rehl is prepared to be cross-examined by the DOJ, and Dominic Pizzola was expected to take the stand today as well. Cheney says that courts have consistently agreed that public access to the proceedings is urgent and necessary, but in this case, the judge is acting to limit that access in what might be the most important January 6th trial of all. And Kyle Cheney does great reporting, but he is no pro-Trumper or pro-J6er or anything like that. He wants to see it as much as everybody else does. And he is wondering why this judge is silencing this. Julie Kelly dug up the story, and she's a great follow. All of these are great follows. Says that a court official didn't cut off the sealed proceeding. And this was the story that was published about the sealed proceeding. CNN says that a judge in a Proud Boys case denies a mistrial motion. We're going to read this motion in a minute. But here's what the hearing was about. The federal judge overseeing a trial of 5 Proud Boys denied a mistrial motion. In late March, several jurors reported 2 incidents in which they were approached outside the courthouse by members of the public. That happened in a sealed proceeding that was inadvertently streamed to a media room. Kelly denied a mistrial motion in that proceeding from all 5 defendants, saying that every member of the jury was questioned about the interactions and confirmed they could still be fair and impartial. Kelly denied motions from other defendants because they said none of the jurors expressed a concern that this would affect their service. He said he instructed the jury to disregard those interactions. The ruling ends an argument over how to handle these incidents, and Kelly described these interactions in detail under seal. In one instance, 3 jurors were walking away from the courthouse when they were approached by a man on a bike. The man began discussing the trial. He was watching at the courthouse, and while it was not clear if he mentioned the Proud Boys or the defendants by name, the man said that the case was interesting and called a recent defense witness crazy. The individuals did not say that he knew they were jurors. 3 jurors told Kelly, the judge, that they thought the incident was odd and weird, but they didn't become concerned until they saw the same man sitting in the courtroom the next day, looking at them and whispering to someone else in the gallery. One juror told Kelly that seeing the man gave her a weird feeling. So some weirdos watching these jurors and making his way into the courtroom. There was another instance. Kelly said that a juror reported seeing the same man at a metro stop on 4 separate occasions. The first time she saw the man, the juror said that he asked her if she was serving on a jury, but she didn't mention any case specifically. Kelly said that the issue was referred to the U.S. Marshals, who went to the metro station to find him, watch the man walk into a homeless shelter. From any view of the photos, it was certainly plausible that he was homeless. Now, after his ruling on Thursday, courtroom staff said the video was being streamed in the courthouse. He says, well, I guess there's nothing we can do about it now. Shut it off now, I guess. And so they did. And that was Judge Kelly and the proceedings. Now, the proceedings were cut off today, but they were apparently reopened near the end of the day. And Brandy Buckman shared that with us. She says, the media room has reopened this afternoon. I'm now live tweeting again. At the end of the day, I'll provide a recap from earlier when the feed was cut. So she's getting caught up, and of course we'll take a look at what happened today, and we'll summarize more of that tomorrow and see what actually happened. But there were some very interesting filings in the Proud Boys case. The Proud Boys judge denied the defense motion to dismiss the case. We read through this one on behalf of Roger Roots, on behalf of Dominic Pizzola, was submitted previously, saying that the government was involved in all sorts of malfeasance, including the Jenks material disclosure, which was the spreadsheet that was sent over and contained a bunch of those secret hidden messages in there. And so the judge said, sorry, defense, you are denied. Here's what the order looked like. Not too long. It is 10 pages. United States versus Dominic Pizzola. The memo order coming out from Judge Kelly denying the defense motion to dismiss. The judge writes, before the court are two motions from defendant Pizzola to dismiss the indictment and declare a mistrial. The first motion is for dismissal with prejudice or for a mistrial, and the second is a motion for a dismissal, and he's referencing the motions. He says on top of the relief that Pizzola seeks, he also wants an evidentiary hearing or special counsel to be appointed. What is he arguing? He says, well, a couple things. The evidence has failed to show his guilt. He has been deprived of exculpatory evidence, video footage that was not given to him. That's the Tucker footage. The government has invaded the attorney-client privilege by snooping on emails and by sending informants into attorney-client meetings. And four, the government has engaged in other misconduct. And we've seen a lot of that here, including allegations of 50+ informants who weirdly didn't know about an insurrection plan. For the reasons below, Judge Kelly says, I know this is going to be shocking for many of you at home, the court will deny both motions, which lack legal and factual support. This is obvious. Okay, these motions were always going to be denied. The judge is not going to dismiss this right in the middle of trial. Especially this judge, especially based on what we've seen so far. But here's what the judge says in his reason. He says, Pizzola's first argument is that the evidence has disproved his guilt, but a dismissal of the indictment must be based on a defect in the charging document itself. The court is limited only to the face of the indictment in evaluating the propriety of the dismissal, so it must accept this allegation as true. In other words, the court can't make a decision right now. If the evidence can't sustain a conviction, you got to file a judgment of acquittal, not a dismissal. Saying this is the appropriate motion to be filing. You can file it at the close of the government's case. The court is reserving ruling as the rules allow. Thus, no relief is appropriate. So we are now reconsidering that. He says that Pizzola has not been deprived of any exculpatory video. The defense is saying that we didn't get access to all of the discovery, all the body cameras, all the materials. They say Tucker got it. We didn't get it. Pizzola makes another argument. He says that our argument is that we've been deprived of this evidence. He says that conclusion relies on the legal premise that the video footage is exculpatory and that the factual premise that the footage was not produced to him in discovery. They say Pizzola hasn't done either of those. You got to show two things. One, it would have shown you're innocent, and the judge says, I watched the footage. It doesn't do that. And two, you got to show that you didn't get the footage when you got all of your other materials, and you haven't shown that either. Say a defendant can show that the government violated its obligation if the evidence is favorable to the accused, that it was willfully or inadvertently kept away from the defense, and that it's material. They say that here, Pizzola hasn't shown any of that. Hasn't shown that the video would show he's innocent. There's nothing that shows that it would rebut that charged defense. Pizzola's defense, the judge writes, says that the Senate chamber was never violently breached, and there's no evidence of any raucous or extremely disruptive or violent demonstration. Judge says, I don't care about that. Pizzola has not shown how any of this relates to an element of an offense or how it relates to him at all. Thus, it doesn't tend to show that he's innocent. Judge says there was no evidence that has been suppressed. The government reports that it sent him most of the footage, but counsel says that they were, quote, unfamiliar with it. But that's not good enough, says the judge. Whether counsel viewed the footage is not within the government's control, so you can't say it was suppressed. And we've also seen this. The government has been very dishonest or very, I would say, unfair in a lot of their disclosures. Remember, in any criminal case, the government has everything. They have everything. They've got billions of dollars, entire institutions. They got the DOJ, the FBI, the Capitol Hill Police. They've got all their investigators, detectives, everybody's involved, okay? They got everything. And the rules are rigged in their favor, and they've got judges. They've got the whole system that's just sort of set up for them. And then when the defense says, hey, can I have some evidence, please? Can I have just a little bit of evidence so I can defend my client and get just a snippet of what I need? The government either beats them up over it and says, hey, fishing expedition, you're not entitled to that. Why do you need all the video evidence and why do you need all this stuff? And they beat them up over it and they fight for it for forever, or you just never get it. So the defendant has to litigate that, or they over disclose, which has come up in this trial. We've already covered that here. In the middle of this trial, the defense asked for something These loser prosecutors said, hey, we're going to get 3,500 pages of material, put it in a wheelbarrow, and dump it over on the defense table and say, here you go, jerks, you wanted it, and just dump it on them. And then the defense said to the judge, hey, judge, this is insane. And then the prosecutors came back and they said, oh, it's only page 45 to 47. That's all we're referencing. And then they said, well, why did you give them 3,500 pages? And they said, well, because they might want it all. So they bury it in discovery or they don't give it to you. It's gross behavior. Basically, this is the latter argument. They gave him a bunch of stuff. The defense says, we didn't see that. The judge says, well, sorry. Should have watched it. They say that even now, Pezzola is familiar with the footage now. Judge says a Brady claim is rarely successful when they obtain the information in time to use it at trial. And now we're in trial and you hadn't begun presenting your defense, so you could have used the footage. They say that there was no constitutional right, violation of Sixth Amendment rights for intercepting his communications. They say the court has already held that in denying Real's own motion that he waived any claim on this platform. Do you see that? This is so, it makes my blood boil. Just so we're clear on this. If you're a criminal defendant and you're in jail and you're using the jail system to send an email to your lawyer and you click a big box that says you understand you're waiving your privileges, that also waives your messages to your lawyer. Judge has said that's perfectly okay. It's waived. He waived any claim to privilege over those communications with his former attorney. In any event, the judge says, skipping over it because he knows how horrendous this is, even if Real had not waived the privilege, Pezzola lacks standing to assert the right of his co-defendants. Okay, so now it's a standing argument embedded in a waiver of privilege. The judge says there's no evidence of government misconduct. They say Pezzola's fourth and final argument is that the government misconduct warrants dismissal of the indictment. His conclusion is based on messages sent to FBI Special Agent Nicole Miller that the government inadvertently disclosed. Judge says the court must evaluate the request for a dismissal under daunting legal standards. Just so we're clear, the judge is setting up a reason why he's not going to dismiss this. They notice it's extremely powerful. It has to reach a demonstrable level of outrageousness. And the judge says we haven't gotten that here. Pezzola only tries to surmount that with conjecture. The closest he comes to claiming that there was coercion by the FBI is that it tracked emotional states and family relationships and put pressures on guilty pleas. But he doesn't point to any message that justifies that assertion. He claims that FBI agents admit to fabricating evidence, but those statements do not hint at coercion, violence, or brutality. In any event, the statements themselves and the government's explanations debunk Pezzola's theory and make clear that no relief is warranted at all, let alone a dismissal. The first message might relate to fabrication of evidence only if the person was present for a communication. But Special Agent Miller's sworn testimony contradicted that thesis. And she swore, so the judge says she's honest and she's true, and I believe her. She explained that the agent is the supervisor agent and the system does this, and it does not allow for a person listed as present to approve the report. So the agent asked the person to just edit the supervisory role, right? All just a big technical explanation. In short, the judge says, the uncontroverted record reveals that the agent's request to alter the report stemmed from a simple miscommunication. You see this? Simple miscommunication. That's all. At the end, there's no evidence to say that it was altered nefariously or otherwise. It's probably true. Do you know why there's no evidence? Because the judge didn't give it to us, didn't allow an exploration, didn't demand the government disclose a ton of other things. The judge just says, hold on a minute, this is scary. There's these documents and you guys can't, investigate any further. And then says, there's nothing nefarious. The government has proffered a similarly anodyne explanation for the second message. They just said it's a routine part of the life cycle, which is why they had to delete the evidence. In sum, the court is satisfied. We don't need any evidentiary hearings. He says the defense is crying foul play on unfounded speculation. There's no evidence in this. The court has already cautioned the defense this has no place in this courtroom. The FBI agent provided a full and uncontradicted explanation of the first message under oath. And as for the second message, it's consistent with the government's representation. Nothing in the record suggests that the evidence that the agent says that she was tasked with destroying had anything to do with Pezzola, with this case, or with any J6 cases. It was just a bunch of evidence that had to be deleted in a message. Moreover, because Special Agent testified that she never reviewed these messages, it makes sense that this had no connection to this case. And for all those reasons, the judge says the court will not conduct an evidentiary hearing, and not one of Pezzola's contentions withstands scrutiny. And so for those reasons, it is hereby ordered that Pezzola's motion for a dismissal is denied, and his other motion is denied. So ordered by Judge Kelly. Timothy J. Kelly, United States District Judge, April 16th from the D.C. Circuit Court. Ugh, gosh, just gross. Motions to dismiss are routinely denied. That is not a surprise. The contortions with which this trial has been allowed to fester in order to fake that this has been, we'll just leave it there. Now, I want to carry on because there's another filing that came out. Defense attorney Carmen Hernandez, representing Zachary Real, submits a motion to strike. She is asking the court to delete some evidence, essentially, some testimony that came into court, to remove it, or to either allow the defense to supplement it, to support it, so that we can have what's called completeness. If the government is saying that the Proud Boys are a bunch of maniac, violent monsters when they're marching around, well, maybe the defense should be able to show some evidence that that's not true at all, that they're not that way, and that many of their other marches were done in total compliance with the law, and that some of their more rowdy protests were not because of them, but because they were attacked by other people while they were exercising their free speech and their free association rights. The rule of completeness is Federal Rule 106. You see here, it tells us, the rule is if a party introduces all or part of a writing or a recorded statement, an adverse party may require the introduction at that time of any other part or any other writing or recorded statement that, in fairness, ought to be considered at the same time. So if the government is going to be playing video after video after video of the Proud Boys apparently being violent maniacs, maybe we can introduce this video where the police are saying that they weren't breaking the law at all and they were just marching and they got attacked. Let's see how Carmen Hernandez breaks this down for us. She writes, this is Zachary Real's motion to strike the proposed cross-examination materials. She says that this court should be striking those materials that the government intends to use during the cross-examination of Mr. Real. They want to introduce social media videos relating to a Proud Boy rally that took place in Kalamazoo, Michigan, August 15, 2020. The videos that the government seeks to use do not impeach Mr. Real's direct testimony. He didn't even talk about those things. And these videos are not properly authenticated. They're inaccurate, they're incomplete, and they paint a false narrative. And if those videos are used by the government, defense says we move to admit a press conference held by the public safety authorities on September 8th, which presented the body-worn cameras from the rally. So the government has some videos, and Carmen is saying, well, we've got our videos from the same rally, and we want to introduce those. At the rally, the Kalamazoo public safety chief explained it was not the Proud Boys, but it was the counter-protesters who instigated, carried weapons, and that they were the catalysts for the violence that occurred on the day of the rally. Now, the government opposes the introduction of this law enforcement press conference because they hate that conclusion. And they don't want the body camera videos in, and they don't want the surveillance footage in, or the radio communications. Because the government doesn't care about really the truth. They care about getting convictions. If they wanted the truth to be in, then they could just show this video, which I will show you shortly. Carmen continues. She says, the government has produced 4 videos that it proposes to use in cross-examining Real. It's from the rally. File names are the 4 videos: Blondie on Twitter, Fashion Tantista on Twitter, Fritz Klug in Kalamazoo, and Fritz Klug on Twitter. The government has not otherwise identified these persons as more fully set forth below, and they provide no basis for a finding of reliability. Where did these videos even come from? Defense says these videos are inadmissible for several reasons. One, they don't impeach Mr. Real. They do not show Mr. Real using violence despite the counterattacks by other violent protesters. They say, second, the government has not provided authenticating information for the information. The videos are not accurate representations of the events that took place that day, as they depict select non-sequential portions of the events posted on Twitter. Now, one account in particular, the Fashion Tantista account, raises issues about the poster's objectivity and provides no reliability about the authenticity of the videos. There's no basis for determining how the video had been edited. The account cover photo includes what appears to be a gas mask surrounded by a smoky substance. The Twitter profile self-identifies as the name War Warner. Location, flaming hell. Neither term is defined, but both terms implicate violent imagery. Here's a screenshot. You see, this is the person where the government is getting their videos from. Forever fighting fascism fashionably, living in flaming hell. And so the defense is asking for exclusion of material. They say at the same time the government opposes Mr. Real's request to introduce a video. There was a press conference that took place. It's hosted on Zoom. It is an accurate representation of the rally, and this is the YouTube video there. During the press conference, law enforcement officers detailed the public safety response, and they noted that counter-protesters were the catalysts to the violence. Indeed, the police videos showed the Proud Boys marching peacefully through the street. Counter-demonstrators began to violently attack them with sticks and even with a street sign. Let's take a look at that video and we can see exactly what happened here. This is from Kalamazoo, and we can see this is August 15th video summary of the protest. They're stopping and starting the video.
To continue eastbound on Water, and you'll see on the left side of the screen is counter-protesters from the festival site leaving the festival site, approaching the protesters in the street.
Proud Boys are marching. Counter-protesters are coming up.
Proud Boys are continuing east on Water, and the other groups are heading southbound towards them. They're going to meet right on the corner here.
Okay, so you see the Proud Boys are going down the street. There appear to be other protesters coming up upon the grass. The audio you're hearing is from the police. The audio has been added, so they're communicating about what's happening. And the point of this is who is the aggressor? Who is lawful? Who is not? So they're allowing it to continue to walk. You can see some people on the left there, and you see these guys yelling at him now. And we have some content warning in the background, so, you know, sometimes one or two might sneak through. But the police are going to start commenting here in a minute. Okay, so now you see other people from the left. This guy's just taking pictures now. And somebody jumps into the crowd.
All right, you have
Here's the police.
Skinnier black male in a gray t-shirt who has now entered the middle of the Proud Boys group and is blocking their travel. They're trying to get him out, and they're continuing eastbound. He's now trying to fight the majority of them.
Okay, so now we see, right now things start to get a little bit rowdy because somebody else jumped into the procession. And the cops are saying that essentially the Proud Boys were just marching around. Here's an aerial footage. You can see the crowd now starts to get a little bit. So here we are. From the air, Proud Boys are just marching. You're allowed to do that. And then other people jump in from the outside. And then it starts to get rowdy. Okay, so the point of that is that the Proud Boys weren't the people who were instigating this, and they've got a history of not instigating things. During the press conference, Chief Thomas highlighted a portion of the video where the counter-protester threw a disposable frozen cup into the Proud Boys, which the chief said initiated the skirmish. Assistant Chief stated, "The investigation shows that the most of the felonious assaults and those that were armed with weapons like clubs, bats, and batons were from counter-protesters. One particularly violent scene shows a counter-demonstrator hitting an unarmed protester with a bat and knocking him out, an unarmed Proud Boy with a bat and knocking him out in the scene." So Mr. Hernandez is saying, Your Honor, due process requires that if there is one side of the evidence, we should be able to correct a prosecution witness. Under the due process clause, she says the government may not seek to introduce or use in cross-examination videos whose provenance and reliability are not established, and documents which paint a false narrative when compared to known, reliable, body-worn camera videos, surveillance, and contemporaneous radio transmissions that we just heard. The materials produced to the public by the Kalamazoo safety authorities, body-worn camera, surveillance footage, and radio transmissions are the very class of materials the government regularly uses, and the government has used these materials in other cases. So now the government seeks to rely on unauthenticated materials while at the same time trying to mislead and paint a false narrative. Therefore, under the rules, She says, while the court's trial procedures order did not require Mr. Real to produce these materials to the government before it proceeded to conduct its redirect, Mr. Real attempted to resolve this issue with the government to no avail. And so for the foregoing reasons, she tried to ask them about this. They said no. Mr. Real respectfully requests the court strike the videos the government seeks to use in the cross-exam, saying they're not impeaching him, they paint a false narrative, and if they don't strike those materials, allow this video, which we just watched, to come in to supplement the record under Rule 106 and due process. Another great motion filed by our friend Carmen Hernandez, defense attorney extraordinaire representing Zachary Real in the middle of the Proud Boys trial. So the government wants to just take bits and pieces and use them against the Proud Boys as they regularly do. And the defense is asking to strike it or to be allowed to include more of it so that the jurors can see the full picture.